Hey everyone, this is a follow-up to my first video regarding Merrick Garland, President Obama's Supreme Court nominee, and how the U.S. Constitution says that the Senate, the GOP-controlled Senate, must offer a hearing to confirm or not confirm his appointment to the United States Supreme Court. I refer to Article 2, Section 2, and I read what Article 2, Section 2 says, but among the duties of the president and powers of the president are the appointment of judicial nominees. But it says in Article 2, Section 2, the president shall, by and with the advice and consent of the Senate. Specifically, to reread, it says he being the president, shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate. And by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court. Okay. Shall. There is a document written by Adam J. White of the Harvard Business School, and it has to do with the specific meaning of the advice and consent clause of the United States Constitution. And while Mr. White goes through some detail, 46 pages, to discuss the history behind the framing of the advice and consent clause, he then stumbles headlong into a session toward the end of his paper, sadly, that is nothing more than him being Mr. White, cherry-picking historical examples to fit a conclusion he seems to have come to perhaps before he started writing the paper to begin with. And what he said, for example, he says that in which of these cases does the advice and consent to president nominations for judicial office fall? The most obvious difference between the Senate's advice and consent power and clear examples of mandatory completion power is the absence of an unqualified shall directive. The Constitution explicitly states that upon conditions precedent, one branch will function in completion of another branch. Upon commencement of a trial of presidential appointment, the Chief Justice shall preside. The Vice President shall preside over the Senate generally. In clear cases of discretionary completion, the constitutional directive lacks an unqualified shall. For example, the pocket veto clause describes the conditions in which the president may allow a bill to expire uncompleted. It provides no shall with respect to the president's decision to act. In light of these differences, senatorial advice and consent to treaties and nominations appears to fall in the discretionary category. That is where he's wrong. Because he's wrong for this reason. It's very simple. You have to go back to Article 2, Section 2. He shall have the power, by and with the advice and consent to make treaties, provide 2/3 of the senators, and he shall nominate. By and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, and consuls. Note, and I want you to pay attention to this, particularly you, Mr. White, if you happen to see this. And he shall nominate, and by and with the advice and consent of the Senate. There's no break there. He shall, and it's expected the Senate will do its duty to complete that shall. So that is where you, Mr. White, really went off the rails, in my estimation of what you wrote. And that's why I couldn't take the entire work, as detailed as it was, seriously, because of the way you closed it out. But the bottom line is this: the Constitution explicitly says that the Senate must do its duty in providing advice and consent. Indeed, just because the Senate hasn't done that historically with respect to lower level nominations doesn't mean it was acting constitutionally. Indeed, it was acting unconstitutionally. Merrick Garland deserves his time in the sun. Give it to him.